Dans News Extra, tantôt, nous pourrons passer un peu le dernier discours président de la Cour d'appel, Anthony Fernando, l'étant qui n'adresse la foule pour son dernière fois de sa position. Il aussi en a plusieurs les autres individus qui n'adressent lui, à l'occasion, ça inclut Depar Ziz la Cour suprême, en Depar Ziz à côté de la Cour d'appel Samia André et aussi des avocats.
For 30 years, I used words to fight cases, to argue a point of view, to prosecute and to defend. And seated on this bench for more than 17 years, I have used words to draw a line with as much precision as the law allows between what is right and what is not. Words were the instrument of my trade. Words that carried consequences for real people. Words that sometimes change the direction of a life. But today, I must find words for something more difficult. Not for a legal proposition, but for something more personal. And I confess that almost 50 years in the law has not quite prepared me for that task. So let me begin simply and with humility. I'm grateful to my parents, my upbringing, and the faith I was raised in. I'm grateful for the unexpected turns of life. I began my career as a young lawyer in the Attorney General's Department of Sri Lanka at just 22. And there I stayed for 11 years. A reasonable path lay before me, one I could have easily stayed on. Then in February 1991, I came to Seychelles. It was a chance decision to take on a new experience in another jurisdiction. I came having obtained no pay leave from the Attorney General's Department out of curiosity and a certain adventurous spirit, but fully intending to return. But fate, as it so often does, decreed otherwise. I wonder sometimes what I would have thought if the ghost of my future had met me on that tarmac. If he had whispered that the first step I was taking was not a visit, but an arrival, and this place would become my home. I'm grateful to the people who took a chance on me at the beginning, the ones who gave me the opportunities, and the ones who trusted me and to hold this great office. It was Mr. Pesi Padiwala who recruited me as a senior state counsel in 1991. The late Mr. Francis Chansam promoted me as the principal state counsel the very next year. President Franz Albert René appointed me Attorney General in 1999, and I served in that office under him and under President Michel for 10 years. I was appointed to the Court of Appeal in 2009 by President James Michel. And in June 2020, I was sworn in as the President of the Court of Appeal by President Danny Fore. I've held this office under his presidency, that of President Ram Kalawan, and now that of President Dr. Patrick Hermini. Different men, different temperaments, different political backgrounds. But every one of them gave me the respect and the dignity of carrying these roles with impartiality, with integrity, and with absolute independence. I am grateful too for what these two roles demanded of me. The Office of Attorney General tests you in ways the bench does not. As the Republic's chief legal conscience, you have to maintain a delicate balance between serving as the government's chief legal advisor the chief prosecutor, and the ultimate protector of public justice and the rule of law. You must advise without fear and act without favor. Sometimes you must walk into a room where power is concentrated and say quietly and firmly the one thing nobody there wishes to hear, armed with nothing but the Constitution and whatever spine your career has given you. I must state that those who led the country during those years assisted me in getting the balance perfectly right. That matters more than it may seem. I must publicly pronounce that they were always prepared to follow my advice, although sometimes they had initial disagreement with it. That was because they knew that I had told them what was the correct position in law, in all honesty. The Office of Justice of Appeal requires a different strength, that of holding the weight of justice in your hands. Let me say what it truly means to sit on this bench. Not the gown, not the ceremony, but what it feels like from the inside. By the time a matter reaches us, it has already been tried. Someone has already listened, weighed and decided. The parties have already waited sometimes 3 or 4 years since the events that brought them here. They arrive exhausted, sometimes bewildered, always carrying weight. They are not case numbers. Behind every number in that registry is a beating heart, a family, a business, a dispute that has consumed somebody's money, somebody's sleep, and somebody's peace of mind. Our task is not to add to that weight. Our task is to lift it correctly, carefully, fairly, and without unnecessary delay. The impact of judicial decisions on the lives of ordinary citizens must be the driving force behind a judge's work. The moment it stops being so, we have lost the thread that connects us to the purpose of everything we do here. According to Socrates, 4 things belong to a judge: to hear courteously, to answer wisely, to consider soberly, and to decide impartially. To decide impartially, including when that decision is against the state, especially against the state. And so again, for the record, in the last 17 years, no one has ever interfered with my judicial functions. For that I am grateful. And I beg the people of this court to continue to hold that line. Because for anyone to interfere with judicial decision making and for any judge to yield to it would sound the death knell for this judiciary, for the separation of powers, for the rule of law, and for the reputation of this republic in the international arena. I'm grateful to this office and for what we have been able to do in it. When I took this chair in 2020, more than 200 appeals were pending. That is no reproach to anyone. Backlogs afflict judicial systems in the world over. But it was the first thing I saw when I sat down. And it set the terms of everything that followed. We cleared it. Since June 2020, and with the delivery of the judgments listed for hearing at this session, this court would have disposed of 766 appeal cases. Thus, every party who came before us would have received a judgment. When we deliver the judgments listed for this August session, this court will be left with only 13 appeals, all filed since April of this year. I am proud of that, not for my own sake, because behind each of those numbers stood a real person and a real life waiting to move forward. We must always heed to Gladstone's warning that justice delayed is justice denied. A judgment that arrives too late is not justice arriving slowly. It is justice that never arrived at all. The cases heard in this court have not only informed the jurisprudence of Seychelles, they have contributed to the broader Commonwealth. All of my judgments are on sale, and 38 of them have been published in the law reports of the Commonwealth. It is a reminder that though we may be a small country, the issues that come before this court are as real and as pressing as those heard by courts in the largest countries of the world. What we decide here can inform the thinking of another court in another country. And this court has adapted to changing times. I amended the rules of this court untouched since 2005, created a pool of justices of appeal at a real saving to the government, and secured promotions for staff who had served 15 years without one. Small steps, each of them, but steps towards a court that works as those who depend on it deserve. Next, I am grateful to the many people who make up the fabric of this court and this judiciary. To my colleagues on this bench, Justices Robinson, Andre, Gunesh Balagji, Shafri, and Sishinga, Justice Janak De Silva, who is not with us today, Justice Matilda Tommy Woods, who recently resigned, and Justices Lilian Tibatemwa Ikiriku Binza and Igogli Kidingake, who have left us. Sitting with you has been the great privileges of this appointment. A collegial court is not one where everyone agrees, and it really should not be. It is one where our collective reasoning exceeds what any one of us could reach alone. Scripture tells us that iron sharpens iron, one man sharpens another. You questioned my reasoning, you tested my conclusions, and for that, every judgment I have signed is the better for it. To the Honorable Chief Justice Ronnie Govindan, I would like to say something personal. Ronnie was my deputy when I was Attorney General. I watched him grow into a formidable lawyer and a fine jurist. There is a kind of professional relationship that begins in mutual respect and deepens into kingship. That is what we have, Ronnie. Thank you for your support and partnership in this judiciary. Then there are those whose names never appear in a law report, but without whom not one of those judgments could have been delivered, nor this court could have functioned efficiently. Ms. Vadivelu, Ms. Gaitan Gontier, Mr. Dennis Hermit, who has left us, and Mr. Solu, who joined us recently, Ms. Marie Claire, the rest of the Court of Appeal staff, Ms. Juliana Estico, Ms. Marie-Angèle, Ms. Nicole Mathurin, Ms. Peggy Nazib, Mr. Paul Derjac, Ms. Sasha Lima Rivel, and Mr. Christopher. You are the engine of this institution. Without you, nothing moves. Files do not reach judges. Notices do not go out. Parties do not know when to appear or where to go. The court does not simply function administratively. It presents itself to the public as the institution it is meant to be. And that presentation begins with you. I have never taken that for granted, not for a single day. To Dr. Simon Mutungi and Mr. Situ, my Judicial Research Counsel, you have assisted me with the research in complex legal questions that we discussed. You have often looked at issues from a different angle, which helped me to come up with a more comprehensive judgment. And let me also acknowledge the security officers and the cleaning staff who open this building in the morning and close it at night. When counsel and parties walk through those doors, this place should look and feel like a court of law. That is your work. The dignity of these proceedings begins with the dignity of this building, and that dignity is in your hands every single day. And to those whose names I never learned, who greeted me each morning with a smile, thank you all. Special mention needs to be made of Mr. Ansel Kometan and Mr. Rodi Vavo, who kept me safe and got me to court on time. To the members of the bar, you have appeared before me for 17 years, and for 17 years before that, you opposed me in court. You have pressed your cases with skill, with persistence, and occasionally with spirited tenacity. When I stopped you mid-submission, and I did stop you, I hope you understood. It was never impatience. It was engagement. A judge who stops an advocate is a judge who is listening. The advocate who knows how to use that interruption is the one who wins. And I'm grateful more than I have words for to my family, Ramya, Francisca, and Chris Murray. Now let me say in public what is essentially private. Ramya, none of this was possible without you. Not a single day of it. There's an old saying that public service is never carried by one person alone. If that is true, then no one has carried more of this journey with me than you. When we arrived in 1991 with our 2.5-year-old elder daughter, neither of us could have known what lay ahead. Through every stage of this life, you have been my constant companion, my wisest counselor, my greatest source of strength. You endured the long hours, the interrupted evenings, the holidays rearranged around court sittings, and the countless nights when my mind was still in a courtroom I had left hours before, all of it with a patience I can never repay. Francisca and Chris Marine, you grew up sharing your father with the law. Court files occupied the dining table, judgments competed with family plans, but you grew up with that same spirit of justice, and I could not be more proud. Behind every judgment delivered and every honor received stands the quiet steadfastness of my family. I have been fortunate in many things, in nothing more than in the three of you. This farewell is as much yours as it is mine, and I want everyone in this courtroom to know it. And in closing, I bid you farewell. For 35 years, I have constantly been with you. I go, but you, my friends, will continue to serve. Adieu, my friends, to this beautiful country that took me in, that trusted me, that shaped me far more than I imagined. Thank you, Seychelles. It has been the honor of my life.
It is both an honor and a privilege to say a few words on this special occasion as we mark the final sitting of the President of the Seychelles Court of Appeal, Mr. Anthony Fernando. For me, this is not merely a formal farewell. It is a personal one. I had the privilege of serving under Mr. Fernando during his tenure as Attorney General. And from those years on, I have come to appreciate his exceptional legal acumen, his unwavering integrity, and his deep commitment to the administration of justice in this country. Those qualities have remained the hallmark of his distinguished judicial career and legal career. As President of the Court of Appeal, Mr. Fernando has led with wisdom, fairness, and quiet authority. His judgment have enriched our jurisprudence, whilst his leadership has strengthened public confidence in our appellate system. One of the defining features of his tenure has been the exemplary relationship that have existed between the Court of Appeal and the Supreme Court of Seychelles. Ours are two courts with distinct constitutional responsibilities. Yet, under Mr. Fernando's leadership, we have enjoyed a relationship founded on mutual respect, open dialogue, and a shared commitment to the independence and effectiveness of the judiciary of Seychelles. For that, I remain profoundly grateful. The legal profession and the judiciary of Seychelles has benefited immensely from his experience, guidance, and collegiality. He has always been generous with his counsel, measured in his approach, and steadfast in upholding the rule of law in this country. My Lord President, whilst today marks the end of your sitting on this bench, the legacy you've left behind will continue to guide those who will follow you. Your contribution to the development of the law and to the strengthening of our institutions will long be remembered. On behalf of the judges of the Supreme Court, magistrates, members of tribunals, presidents of tribunals, staff of the Supreme Court, and on my own personal behalf, I extend to you our sincere gratitude for your distinguished service to the people of Seychelles. We wish you and your family every happiness, good health, and fulfillment in the years ahead. Thank you, my Lord, for your friendship, your leadership, and your dedicated service. It has been a privilege to have served along you so far. I have no doubt that you have not totally completed your worthwhile contribution to this country. Retired judges are immense pools of wealth, knowledge, wisdom, and judicial experience. And without a doubt, your wise counsel will be sought by many. My only hope is that they do not impose too much a burden on your well-deserved retirement. Ramya, who's here, please make sure that this does not happen. Let me finally say to you, Justice Fernando, I wish you a fulfilling retirement and with much love, peace, and happiness. Thank you.
Thank you.
Justice Fernando, as you preside over your final ceremonial sitting as President of the Court of Appeal of Seychelles, I wish to express my sincere appreciation for your distinguished service to the judiciary of Seychelles. Your tenure has been marked by calm, principled leadership, a steadfast commitment to judicial independence, and an unwavering dedication to the administration of justice. Drawing on your extensive public service as Attorney General, Justice of Appeal, and ultimately President of this court, you have led with wisdom, dignity, and fairness. It has been an honor and a privilege to serve alongside you. Your leadership has left a lasting imprint on this court and on all who have had the privilege of working with you. On behalf of myself, all my colleagues, and all the staff of the Court of Appeal, I extend my heartfelt thanks to your service and wish you continued good health, happiness, and every blessing in the years ahead as you enter a well-deserved retirement. With the highest respect, I bid you farewell, Justice Fernando, and I pray that God will continue to bless you. Thank you.
Often, as we left the court, having had a judgment delivered against us, we wondered why you had not recused yourself in favor of God the adjudicator before we would have had a much better, in our view, result. Life, the philosopher reminds us, is lived forward but is examined backwards. And as I look back over your period among us, I realize that our careers marched pretty much in lockstep. You, 47 years, I, 48 next month. And over this period of time, I have grown personally to admire your independence, your resilience, and your ability. These are, I think, your trademarks, and these are what we will remember from your passage among us. As you move forward to the next chapter in your life, I feel it is fitting that we recognize the contributions that you have made to our country, which have been many and multitudinous. I have sparred with you, as you know, at the bar. I have tried to persuade you from the bar, not always successfully, but that is the business of the law. And we must accept that at the end of the day, the bench knows best, despite our continued misgivings. I have had a particular friendship with you, and you know this, and many people know this. I've had the privilege of calling you Tony, and you've called me Bernard. But the one thing that remained in all of this was that despite this friendship, I knew, you knew, and everybody knew that when it came to deliver a decision, that friendship would be cast aside and the decision would be based on the law. And that is how it should be. And if we have learned anything from your presence amongst us, it is this, that the bench remains independent and should remain independent, irrespective of any friendships that might arise. As you leave, I wish you and your charming wife all the best. Thank you for your service to our country, your long service to our country. Take some rest. Enjoy life. Take time to live. The law is fine, but it is not everything. Enjoy retirement. I hope to follow in your footsteps very soon.
It is both an honor and a privilege for me, on behalf of the Bar Association of Seychelles, to offer a few words as we mark the retirement of Mr. Anthony Fernando, President of the Court of Appeal. Today, we celebrate a remarkable legal career that has spanned decades of public service, both in Seychelles and beyond. From his years as Attorney General to his service on the Court of Appeal, and ultimately as its president, Justice Fernando has made an enduring contribution to the development of law, of our law, our institutions, and the administration of justice in Seychelles. Those of us who have appeared before him have come to know a jurist who combined deep legal knowledge with intellectual rigor, independence of mind, and an unwavering commitment to principle. His leadership of the Court of Appeal has coincided with significant improvements in the disposal of cases and the strengthening of appellate justice. Always guided by the conviction that courts must deliver justice fairly, efficiently, and without fear or favor. As members of the bar, we have not always agreed with every judgment, That is the nature of advocacy and of the judicial process. But we have always respected the integrity and professionalism with which Justice Fernando approached his office. Those qualities have fostered confidence in the administration of justice and strengthened the relationship between bench and bar. There is a well-known observation by Lord Bingham, one of the great jurists of the modern era, and I quote, "The rule of law is not a slogan nor a political catchphrase. It is the foundation of a civilized society." Throughout your career, Justice Fernando, you have exemplified that ideal. Your service has reflected a profound belief in the rule of law and in the judiciary's role as the guardian of it. While retirement means that counsel appearing before him will no longer have to answer his questions from the bench, it also means that many of us will miss the insight and learning behind those questions. Interruptions, as your lordship called it earlier. On behalf of the Bar Association of Seychelles, I express our sincere gratitude for his years of distinguished service to the judiciary, to the legal profession, and to the people of Seychelles. Justice Fernando, as you embark on your well-earned retirement, we wish you good health, happiness, and every success in the years ahead. Your contribution will long be remembered, and your legacy will continue to resonate through the jurisprudence and institutions that you have helped shape. Thank you and farewell.
Aziz Anthony Fernando. Aziz Anthony Fernando s'adresse à plusieurs les autres dans une interview avec médias. When a case has been brought before the Court of Appeals and decided upon, and the appellant feels hard done by, in what instances may they bring the very same case before the very same court again?
That's why I say where there's been a grave procedural irregularity as opposed to a decision on a substantial issue, right? Now, I'll give you one example. Supposing, say on the day of the hearing of the appeal, the appellant, right, or maybe even the respondent comes before the court and say, "My lords, you see, my lawyer who was to take this case and who knew everything about it, who was to argue, was taken ill just now, had been rushed to the hospital." And the bench, if we were to say, "Nothing doing, you argue your case," and goes ahead and gets this fellow to argue, he won't know anything, say a poor layman, then that may be one of those instances where there would be a breach of the right to a fair hearing of a person, because he has to be heard. That would be, so that's why I said it's only in very limited circumstances.
What about
or if a counsel was denied arguing his case. If you're stopped at the very outset, in other words, the bench comes ready with a judgment already, and no sooner the appellant gets up, or the appellant's counsel gets up, the court tells him, no, you don't have to. That may also amount in certain cases. But of course, if the appellant has no case at all, it's always, it is the right of the court to tell the person, you have no case. But yet he should be given a chance to at least meet that comment from the court.
What about instances whereby new evidence may come up? In that case, that was decided before the Supreme Court itself, and then brought here.
No, but yeah.
Would it be looked at in a new?
Again, that would be in a very, very rare situation, because you see, by the time it comes here, the matter has already been heard and determined by the Supreme Court, right? And now the appeal is heard. So it is I cannot think of a situation where some new evidence might emerge. Of course, there's provision in the Court of Appeal rules for making an application to need new evidence even before the Court of Appeal, when it comes up for the first time. That is, if that evidence was not available at the stage when the case was heard by the Supreme Court, then of course, when they come before us, they would always say there was new evidence.
So, sir, this is something you mentioned in your speech about judicial independence, and it's frequently discussed in small jurisdictions. From your perspective as both a long-serving Attorney General and later Court President, where does the real pressure points lie in Seychelles?
Yeah, now there are these cases, very interesting question, because I have dealt with this same issue, I've written on this issue also in one of my judgments. Being a small jurisdiction, right, you see when something happens, especially maybe take the case of trafficking or in drugs trafficking or even, yes, importation. People in this country know who the dealers are, who the Escobars are, right? And then, unfortunately, sometimes because they are so very well known to be, the investigation part is not done completely because they think, okay, this guy is well known, let us take him to the courts. But what happens is at the end of the day, we have to decide a case on the basis of the evidence. A case against an accused has to be proved beyond a reasonable doubt. There are certain standards, especially in a criminal case, beyond a reasonable doubt. So now, the issue is the people sometimes are upset when they feel, how come this chap is well known? In fact, personally, I have heard these comments being made. See, this guy has houses, he has yachts, he has this, he has that, and how come he was let off? Simply because that the evidence that the police had brought before the court was not sufficient. And you see, now also take the case of a murder or a crime that has been committed. You see, would have seen, but if you don't come forward to give evidence before the court will have no other option but to acquit the accused. So people will know. I mean, even I could have seen a crime being committed, but if I don't have the guts to go before the court and testify, then the matter, there's nothing that the courts can, because the court will always have to act on the basis of evidence. Now, when it comes to that, one difficulty we have is, that's what I was going to say, a problem in the small jurisdiction. So, there's a known criminal, right? He has been brought, the investigation has been very poor, but sometimes he has been convicted by the lower court, right? And then when it comes to us, when we examine the case very closely, we suddenly realize that the case had not come up to the level of proof that was expected in a criminal case. So we have to let him off. There have been, deep down in our own minds, even we know that this person is guilty. But at the same time, there's nothing we can do. Because if that is the case, if we just convict without evidence being there, turn out to be a kangaroo court. You don't have to have a court then. This guy is a well-known drug dealer. This chap is the one who committed the murder. So we just convict him. That evidence must be there, given on oath before a court. So that is a difficulty the Court of Appeal sometimes faces. We can be criticized sometimes of letting off people whom the general public very well know are guilty of the crime for which he had been charged.
Judges from your court, who's also been part in national inquiries of late, Justice Shafiri and Justice Tomi Woods.
Yeah.
There's been the notion that this may be a conflict of interest, if ever. Some people are found to be guilty, brought before court, and then they appeal. They come before this very same court, whereby these judges are, and with a panel of judges who are basically friends with the other judges on there. What's your views on that?
Yes, certainly, of course, they won't be able to hear the case, the first issue. They'll have to recuse themselves. The second issue is you are going on the basis that they might influence the other judges, or the other judges may, because of friendship, will not want to go against whatever decision that they have taken. Now, I would say that is what you mean by independence and impartiality of a judge. You may be a very close friend, but that doesn't mean in order to side with that judgment, you are going to give a judgment, uphold the judgment of the other court. But of course, when it comes to commissions of inquiry, I must say, they don't make any judgments. They only make recommendations. So they don't have the power to punish or to give a judgment against a person. They can only recommend, and it is thereafter left to the police to investigate, the Attorney General to file a case, and then only a court can come to a finding. So there's no issue of a finding being made. Of course, I know, recently I've also heard, you can challenge the manner in which a commission of inquiry can be. That's a different matter. That is what you call judicial review. Of a decision of an administrative body. That's a different matter. That is where they challenge the whole process itself, that they did not follow the normal procedures.
Et plus tard, dans une interview avec service de la Cour suprême, Ronnie Govinden, il donne un petit peu plus de détails le bon temps de travail avec Ziz Anthony Fernando et aussi il adresse plusieurs les autres sujets qui dans l'actualité en ce moment.
Mr. Fernando, nous travaillons ensemble pour beaucoup de temps. On commence la bureau attorney général avec Mr. Chang Sam. Et puis, straight away, pendant le retirement, Mr. Chang Sam, on commence mon privilege en bas la direction Mr. Fernando. On fait 9 ans ensemble. Et puis, on a elevated to Seychelles Court of Appeal. Moi, je suis attorney général. Il est invité Court of Appeal. Moi, je suis attorney général. Moi, je suis appuyé devant lui. Ou soit mon bon subordinate officer qui apparaît devant lui. So, là, nous voyons déjà dans des différentes façons et comment son subordinate, attorney général, parce que tu travailles comment son employé, et puis pour 10 ans, on appuie devant lui. Après ça, moment vient la Cour suprême, et mon bon juge manal devant lui, comment un PO juge qui, d'après nos constitutions, il administre la justice et il considère appel. Et après ça, comment se disent aussi, encore, il apparaît comment l'élection panel, l'élection à la Cour, comment ça dit, qui fait une détermination, une bonne décision que la Cour suprême fait. So, ouais, que différentes façons, nous sommes capables d'interagir avec ça dit, pour tout ça les temps, qui soit comment un officier légal gouvernement, soit comment ils disent. Et ça apporte beaucoup d'appréciation pour son qualité, son différentes qualités, comment un monde personnellement, avec son capacité professionnelle, il y a des gens plein avec intégrité, professionnalisme, il y a des gens qui sont vraiment droits, qui m'en apprend beaucoup avec lui, qui croient dans la justice, qui croient dans le rule of law, et il y a une passion pour certains sujets de la loi qui, où il décide de là, il est difficile pour avoir une faute avec. So, là, il prend une décision, parfois, on dit qu'il faut vraiment on fait une faute, alors si tu as besoin de corriger. Et de l'autre façon, qui m'ont apprécié avec Tenio Justice Fernando, c'est que dans ce rapport entre la Cour suprême avec la Cour d'appel, c'est cordial. Vous connaissez, nos constitutions écrites des différentes cours. Et parfois, on ne peut pas apprécier que la Cour d'appel et que la Cour suprême, des différentes cours qui sont constitutionnellement indépendants, qui nous pas travailler ensemble. Il y a des différentes administrations. Nous, dans le même bâtiment, c'est à part qui nous joignent comme des officiers judiciaires, de temps en temps, mais nous pas interacter camarades pour créer ça l'indépendance. Vous comprenez? Et nous sommes capables de travailler pour administrer la justice en préservant l'indépendance de la Cour et en appréciation l'importance de toutes les institutions, qu'il soit Banziz, en bas son leadership, ou soit son bon staff. Et ça, il amène une bonne atmosphère pour faire ce qui a, à the end of the day, les peuples doivent bénéficier d'un système de justice qui est bien administré. Sur l'autre côté, je crois pour qu'on ait arrivé à un point dans la carrière n'importe du monde, même si un juge, il a besoin de retard, même s'il y a un potentiel, il a un potentiel intellectuellement, il y a encore sharp, physiquement, il y a encore sharp, 70 ans, si on c'est là, on a besoin d'exit. Et ça qui est arrivé. Et c'est ça que m'ont dit, peut-être, nous ne pouvons pas à la fin, comme Mr. Fernando.
Ou-même, comment si Dieu, chairman, sa comité pour évaluer la loi pour the way forward. Est-ce qu'il y a un candidat qui will go to pour the next 15-25 years, la loi c'est celle qui m'a nous pour aller.
Dans le pays, les autres qui ont une constitution, les autres qui ont un conseil constitutionnel Et conseil constitutionnel son importance c'est pour keep under review ban provision constitution. Connaît constitution il y a living and breathing document. Dans pays dit non besoin à interpréter constitution d'après les créé ban façon qui ban législateur tu fait tu peux penser là tu peux créer nous pas subscribe tout ça ban vieux non. Nous quoi vous dire constitution besoin adapter li avec les moments que individu devant nous pour interpréter ça veut dire bien qu'à évoluer avec une perspective qui changée d'un pays soit socio-économique, culturel, politique à cause du besoin capable apprécier sa situation qui devant les modernes. Comprends? So, nous n'a pas conseillé et même si on a Seychelles Law Commission son conseil c'est pour revoir ban law pas nécessairement parce que pas nécessairement constitution et constitution pour les gagner revoir faut des par reconnaître un processus politique aussi qui vient avec faut des ça dit monde qui peut pousser pour amender la constitution et ainsi pour fort dans l'Assemblée nationale qui montre tout comment dire si nous prenons une réforme constitutionnelle il besoin bipartisan il besoin across politics que tous les peuples sur la cause à the end of the day c'est 60% les peuples c'est loi qui besoin support par un référendum aucun amendement constitutionnel qui ne prend l'impact par une envie faire par dit pour dire peut-être une loi pour réviser la constitution.
Un bon autre point, il discipline qui c'est trois derniers 4 ans qui monte pas encore Justice Fernando in strict là in have a go at ban avocat même senior devant ban la cour ici et ça y aussi il y a quelque chose qui nous peut voir il carry over tout ou la cour un petit peu la discipline.
Oui. Après chaque session la cour d'appel il y en a un ou des avocats qui gagnent disciplinaire à cause des autres relations comme une condition de relation entre les autres clients ou soit entre les autres avec la cour. Il y a un retard pour faire une procédure ou soit les autres misappliquent l'argent client ou soit les autres pas assez proactifs pour pousser l'intérêt des autres clients devant. Et là, la cour d'appel il envoie ça une caisse ici pour nous la cour suprême prendre action. Et tout ça va dire monde qui met devant nous. La Cour suprême qui fait un comité disciplinaire qui a créé, que Depar Ziz, il écoute ça qui est son corps, il écoute ça qui est sa avocat, il écoute ça qui est sa complainant, et là, basé sur sa recommandation que la Cour d'appel fait, il prend action disciplinaire contre sa avocat. So, il y a plusieurs instances que l'avocat a une fine, parfois une somme assez haut, et les autres payés. Et il y a un point qui concerne, qui est encore peut considérer de quelle façon plus appropriée vous connaissez M. Fernando Ziz Fernando-11-08-2026 quelle façon plus appropriée pour effectivement discipliner avocat. On est dans les autres juridictions il y en a une société les avocats law societies law council il y en a un peer review system que tout bon avocat il a besoin d'un membre de sa conseil. C'est pas un conseil dentiste, conseil docteur, conseil real estate agent dans le pays. Moi subscribe à l'idée que nous avons besoin d'un conseil avocat qui l'association ils ont une fonction c'est moi l'association il y a une association qui pour venir membre optionnel. So si on a un conseil que membre il vient mandatoire et ça conseil il y en a une capacité disciplinaire pour discipline ça va dire à part que la Cour suprême a besoin de retenir une certaine capacité pour discipliner l'avocat c'est tout ban qui fait l'offense disciplinaire dans la cour mais quand il y en a pour faire relation entre client avec avocat ça conseille quoi il faut vraiment effectif pour faire ce qui déontologie et éthique profession légale gagne observé par tout son monde.
Un sabani chaud qui dit mon continue faire monter il retard encore une bonne quelque chose qui crée retard il aussi avocat qui autres connaissent la loi, autres connaissent le prôle, autres jouent avec, dans mon 14 jours, dans mon 28 jours, dans mon un long date. What's the way forward, ça?
Non, non, un barreau qui est petit. Non, non, le mot du barreau, ça, quantité d'avocats qui est capable d'apparaître devant la cour, il n'y a pas beaucoup. Là, dernièrement, nous pouvons voir doucement, ben graduates qui en vivent un avocat. À cause pas tout le monde qui a étudié la loi, qui en vivent devant la cour et plaider. À cause lui-même, il y a un défi qui vient avec. Il y a beaucoup de ces lois qui décident de passer dans un processus l'éducation, même d'autres gars qui ont final, ces hommes ne pas venir devant bas. Un premier question, c'est mon encourage un avocat pour prendre un cahier ben barrister. Quand il apparaît devant la cour, il y a un bon défi, mais un défi, c'est ça incentive, ça bénéfice que les autres gagnent. Il plein, il plus que les autres, tu peux faire un office job, comprends? À cause là, autres pour les autres l'école, les autres capacités pour apprendre, gagner l'expérience, capacité pour augmenter notre advocacy skill. So, si nous gagnons plus de monde pour apparaître devant la cour, pour avoir plus d'arrêt, pour avoir plus de quantité de ces lois, qui nous pouvons enlever les autres, pour les autres apprendre nos caisses pour mener en cours. Ça y est. Et quelque chose aussi, moi, pour conseiller les gens qui est en question en cours, soit qui est en virement question en cours, c'est soit des autres avocats. Si tu as le côté avocat, il dit comme ça, il est busy. Qui est un bon avocat, right? C'est moi busy son diary plus qu'en 2027. C'est le point de vue. Ça, il y a une responsabilité personnelle, ça. Ou pas qu'à respecter, ok, ce gars décidé 2025, 2026, quand ça dit, mon dit comme ça, il faut le time plein jusqu'en 2027. So, besoin de 6 billets avec ça, avocat, jusqu'à là, il a fait un slot available pour nous. Nous pas qu'à entrer là-dedans. La cour pas pour qu'à entrer dans une relation. Il y a un privilège, ça. Relation avocat avec client, c'est un contrat qui est formé avec ça, avocat avec le client. So, il y en a plusieurs avocats qui m'ont il y en a capacité pour mener question pour effectivement et pour faire ici, pour dire qu'il gagne son case de façon appropriée, qui il a, c'est moi il va payer un client. À cause, il y en a 3-4 avocats qui ne font son nom. Il y a un bon avocat qui ne fait son nom, mais plus ou pour gagner un bon avocat qui ne fait son nom, qui est vraiment bon, exceptionnel, c'est plus difficile pour les autres capables de prendre une caisse et pour t'aider. So, ça aussi, mon conseil, c'est qu'il à l'écoute des 3 avocats et à l'écoute de ça, qui promène une caisse plus bonne, mais aussi ça pour donner un bon service. Et puis, il y a un procédure, par exemple, on dit procédure légale aussi, nous sommes besoin capables de la possibilité d'amender et changer. Et la Court Seychelles Law Commission, Reform Commission, il y en a un grand rôle pour jouer. Une procédure qui nous a une procédure qui est effective pour 10 ans, 20 ans passés, civil procedure code, criminal procedure code. Et là, nous dans un processus pour amender sa code procédure, pour faire ci qui y amène plus la vitesse d'un mouvement case en cours, en servant différents moyens technologiques, par exemple, qui nous en vigueur là, et aussi pour adapter les d'après les best practices qui dans un pays démocratique, c'est en faisant si qui nous parle contre la Constitution. Parce qu'on a une Constitution parfois établie dans la règle que tu n'es pas capable, même si tu as envie. Par exemple, il y a des gens qui gagnent ça, tout ça va une procédure qui est assez longue, parce qu'on les sont qui ont écouté ça pour changer ça.
L'indépendance, la Cour suprême, ça dernier 5, 6, 7 ans, puis il y a questionné. NP aussi, c'est dit, il est faveur, l'autre dit, il a l'autre faveur, un petit peu ou stance, là.
Ou pas pour jamais gagner ça bien. De n'importe pays démocratique, pas ici, c'est que tout le monde a un choix pour donner l'opinion, son appréciation, la décision. Jamais pour qu'à dire 100% de la population est à la Cour suprême indépendante. Tout le monde a un groupe de monde qui peut dire ça, la Cour peut prendre un certain parti comparé avec un autre parti. Comprends? Si par exemple, un case est déterminé, tout le monde a un parti gagnant et un parti perdant. Sa partie qui perd là, il peut avoir plusieurs raisons à cause d'une perte. Il y a des raisons politiques, il y a des raisons perception, corruption, il y a raison, discussion personnelle. Tout, et il a accepté son défaite et il y a la cour d'appel. C'est pendant tout pour 50%. Le système de la justice comme ça, il m'a assez. Écoute, s'il n'a pas de problème avec sa décision, il prend un problème avec sa Ziz. Et given qui nous communauté, type pareil, type, que tout le monde, contre tout le monde, il faut besoin capable d'une raison à cause de sa Ziz, il donne des décisions contre lui. Mais c'est vraiment rester fermement, quoi, qui nous prend nos out of office, nous prend nos serments en bas de la Constitution et nous fait nos décisions d'une façon de what. Si un monde qui apparaît devant un Ziz, il y a une perception, ou soit il y a une raison pourquoi vous dites ça Ziz, pas pour donner la justice, il y a sa procédure recusal pour te demander pour sortir et sortir. Et s'il y a une raison pour sortir, il y a plusieurs instances qui moi mon fait et plusieurs les autres Ziz fait. Et on a une décision là, ou a décision parfois contre le gouvernement, parfois il y a faveur du gouvernement, parfois il contre l'attorney général, parfois il y a faveur de l'attorney général. C'est la justice qui bouge dans la direction. Et perception, par exemple, aux hommes pour capable de tirer, à cause il a nature humain. Il a nature humain pour parfois une bonne raison, qui n'est pas nécessairement une raison appropriée, pour amener une connotation avec l'institution pour dire ça l'institution est comme ça, vous soyez pas là-bas. Si on n'a aucun exemple concret, par exemple, qui ça dit qu'on prend une décision pour une raison ultérieure ou adverse, il y a une procédure constitutionnelle pour mener contre sa Ziz, soit contre sa bench. Par exemple, devant un conseiller appellement Depar Ziz. Vous comprenez? So, nous besoin d'observer sa procédure si ça est le cas. So, mon conclusion finale, c'est ça, une perception qui inexistait depuis les CCL n'existait. Depuis 1993, quel gouvernement qui est au pouvoir, tout coup, il y a un groupe du monde qui peut dire ça, Depar Ziz, il y a faveur. Si vous êtes dans l'opposition, Depar Ziz automatiquement pour faveur du gouvernement. Et ça pour continuer. Mais moi qui m'ont demandé ces lois, c'est pour on a sa croyance et get quelque chose comme bien puis assez on the ground. C'est comme ça, regarde l'administration de la justice, pas regarde perception. L'opinion tout pour l'opinion, mais regarde ben fait qui peut arriver devant les autres. Si vous n'avez pas comprendre, demande ben du monde qui est gazé avec le système de la justice, à approfondir les autres connaissances, les autres avoir qui arrivent.
Il y en a sa perception là qui il y a un conflit of interest. Et Depar Ziz la cour suprême, le panel la cour constitutionnelle qui nous a dit 10e amendement constitution et il y a aussi lui-même il y a un bon commissionnaire, la commission qui peut faire l'enquête dans la prison et un bon point qu'ils ont pu guetter il y a 10e amendement constitution justement côté soldats qui entrent dans la prison et intervenir à un certain point côté des dimonin et soldats qui sont impliqués alors 10e amendement alors un petit peu sa perception qu'il y a un conflit d'intérêt un Ziz qui peut faire l'ouvrage commissionnaire qui a pour faire ça l'amendement et lui-même qui est ça l'amendement.
Moi pas pour répondre à cette question à cause du subjudice. Il y en a un case déjà devant la Cour suprême, un case judicial review que ça point gain élevé. So il y a un case que si un juge de la Cour suprême qui est dans l'office, il est capable même un conseil de commission après t'es pas président. Ça est déjà pending, il subjudice pas pour à cause de là. Et aussi moi pas connaître aucun appel qui pour gagner fait contre sa décision la Cour constitutionnelle devant la Cour d'appel. So on va pas capable éthiquement professionnel pêchement cause de là.
Eh bien, nous arrivons à la fin. Ça est une news extra. Merci pour qu'ils nous suivent et gardez-vous avec nous pour nos prochains programmes. Bonsoir.